Hi, folks. It's Andrew Weissmann, and it is Saturday at 2:51 p.m. my time. And I'm here with Ryan Goodman, who I usually think of as my co-teacher, since we teach national security law. But Ryan is a professor at NYU Law School, and he also is the editor in chief of Just Security. And for people who listen to me on Substack or on MSNBC, you probably know this because I'm constantly talking about Just Security. And again, it's Just Security, and it's a law forum that you can find online. Just Google it, and it is really spectacular. And the thing that I've been calling out over and over again is its litigation tracker, but where they track all of the various lawsuits that have been brought against the Trump administration since January 20th. And Ryan, I think I heard you the other day say that the tracker is up to 190, 190. Is that right?
It is not. It is now 196.
Okay, so I must have looked at it just an hour ago.
That's right.
Um, it's such a great resource, and just to be clear, it's not alphabetized, and it's not like you just have to find stuff on your own. It's put into buckets by category. So if you're looking for everything about birthright citizenship, it's all there, and it's very much for both lawyers and non-lawyers. So anyway, that's a big pitch for Just Security. It's got a lot more than litigation tracker. It's really an incredible resource. So Just Security, with Ryan as, he won't say this, but as the lead, has just started a Substack as well, because they really want to make sure they're using media in all of the ways that are most accessible and make themselves available to you. And I have subscribed and started listening to it. It's really great. So that way, if you want to read really interesting articles, if you want to just hear Ryan's mellifluous voice, if you want to listen to their podcast, there are all sorts of ways to take advantage of it. But Ryan, I'm going to try and kick us off because we are here, and I started by saying it's Saturday at 2:52. It's now 2:53 because I've gone on and on about Just Security. We are going to talk about the really, truly dramatic events from yesterday, culminating in something that happened just this morning in the Supreme Court of the United States that I think a lot of people who are listening to this have heard of. And I thought we might do, Ryan, is start with the Supreme Court decision this morning and then work backwards about how did we get to that? And then we'll end with some thoughts about where is this going? What's our view of what the Supreme Court's doing, of the state of the law here? But why don't we start with that? So at around, I believe, 1 a.m. this morning, the Supreme Court issued a decision that appears to be 7-2, with two noted dissenters, which so presumably seven in concurrence with the decision. And it's a short decision. What did the Supreme Court do?
So the Supreme Court essentially, oh, and also, thank you for the introduction.
Yeah, yeah,
Uh,
yeah.
yeah. Um, so the Supreme Court basically granted an administrative stay, so froze in place the status quo when it comes to the ability of the government to fly people out of the Northern District of Texas under a purported authority under the Alien Enemies Act. So this all came to the head because the lawyers in these cases, especially the ACLU at the forefront, as of Friday morning, had gotten information from some of the people held in detention there in the Northern District in Texas that they were being told that they're basically about to be put on flights and sent and taken out of the country and sent to El Salvador.
And
And
I
so,
think some of what I was reading was that they were already being put on buses
Yep.
And so they were sort of being taken out of detention and put on buses. And I think the a thought was presumably to then be loaded onto planes to be removed. As everyone I think who is listening to this knows, we have um, two plane loads of people who were in a case involving Judge Boasberg, where they are now in El Salvador, and there's contempt issues that Judge Boasberg's dealing with because he ordered those planes to either not take off or in there if they were in midair to turn around. And then in the Garcia case in Maryland, we have another example of somebody who was everyone admits was wrongly removed, who is now imprisoned as we're doing this, is in jail in El Salvador. And the government's position is nothing we can do about it, even though the Supreme Court has told us to facilitate his release from jail. So there's this real concern that once these planes take off, that the courts will lose jurisdiction. And so that is to just to give the backdrop to the ACLU and it getting this word that their clients are being removed onto buses and presumably now going to be flown out. The idea is that if those planes take off, it's not at all clear that the administration is going to comply with any court order. So um, uh, so just to stay with the Supreme Court of the United States, I take it the ACLU, before we get to what the ACLU did sort of to get up to the Supreme Court, presumably they're filing in the Supreme Court saying what we want to stay of to prevent the government from being able to remove these people from the Northern District of Texas and fly them out of the country. Is that right?
That's right, because at the time, the Northern District of Texas, which actually has the case, the Judge Hendricks, is basically not answering the question. And so they appeal both to the Fifth Circuit and the Supreme Court at the same time, which is highly unusual.
So
Usually,
Judge Hendricks, though, is the district judge, the federal district judge. And so there initially was an application to him to say you should prevent this removal.
yeah. So just to back it up with Judge Hendricks, there's an already standing case before Judge Hendricks long before yesterday, long before Friday. And in that case, the ACLU has two named plaintiffs, and then they want to include not just the two named plaintiffs, but an entire class. The entire class would be anybody who is currently held in immigration custody or criminal custody as well inside the Northern District, who the government believes could be subject to the Alien Enemies Act proclamation. And what they want the courts to do is freeze in place right now, just that nobody will be taken out of the district or out of the country, as you say, so that they would be able to, the government would be able to evade court review. And what Judge Hendricks has done is he says he actually denies them a temporary restraining order, which is unusual. Other judges faced with this question in Colorado, Southern District of Texas, Southern District of New York have granted a TRO in such circumstances. He says,
And Judge Boasberg had in sort of the beginning of this whole matter also had granted a administrative stay, correct?
absolutely.
Okay, so sorry, what is Judge Hendricks at the Northern District of Texas federal court, the sort of trial judge level? He gets the application first, and what does he say? Why does he not grant this?
He says, well, your two named plaintiffs, the government has told me that they promise not to remove them. And so I'm not granting you a temporary restraining order because the government's not going to remove them until we hold all our hearings. So it's denied because the action's not going to take place. You don't have a real risk that they're going to be deprived of their rights based on the government's promise. And so the ACLU comes back and basically says, look, that's fine and well for the two people, but we've been in direct communication with the government and we've asked them, can you make the same assurances about the entire class or everybody who's held in custody within the Northern District? And that got super amplified on Friday because now they're hearing that all these other people are going to be taken out of the country. And what Judge Hendricks, so Judge Hendricks is actually just sitting on that. In fact, yesterday he did the weirdest things, which is like he issued orders, but the orders were, oh, yes, we're going to have a hearing as to whether or not we'll certify this as a class days from now. And so that's the imminent risk of all these other people that have been brought apparently from across the country to the Northern District of Texas. In fact, that's stipulated by the government in a later emergency hearing before Judge Boasberg. They've been taken from all over the country to the Northern District to be put on these flights. And yet Judge Hendricks isn't acting.
So he acts with respect to two, but not, with respect to, I was going to say boatloads, but in this case, plane loads of
Yes,
people.
plaintiffs.
The reports from in the media are that there actually have been 5 plane loads of people who, under various authorities, not just the Alien Enemies Act, have been taken to El Salvador to this prison. And so with respect to one question, with respect to the 2 people where the government said, oh no, we assure you, Judge, did they give any timeline? Because that's going to come up, the timeline's going to come up later when we talk about what happened with Judge Boasberg.
I think their timeline is like indefinite. It's basically the equivalent of a TRO. It's saying we're going to give you that same amount of time and the assurance that we will not do anything to prevent the court from exercising jurisdiction over these 2 individuals.
So in some ways, if you were cynical, I plead guilty of this now because
Yeah.
of the
Yeah.
history of the case,
Yes, absolutely.
because this is the case that came from Judge Boasberg,
Mhm.
where he has recounted, and we've discussed in various other forums, why he is so skeptical because he was told, "Don't worry, we're not, nothing's happening," and sure enough, the planes took off and didn't come back. So that's why he has had contempt hearings and made a finding of probable cause of contempt of his order. Um, but so here, if you're cynical, what you see the government doing is saying, with respect to the 2 people, oh, Judge, don't worry, but we're just going to be shoving all these other people under the door, out the door, really, while there's no stay in place.
Yes.
Because you have an issue to stay as to that, and so we're going to try and just remove them. So with Judge Hendricks sort of sitting on the bulk of these people, the ACLU goes to the Fifth Circuit. That's the Court of Appeals over Judge Hendricks. That is known as a fairly conservative circuit. That doesn't, I'm not by any way by saying that they won't follow the law. And simultaneously, which is very unusual, going to the Supreme Court. And that, usually you do it seriatim, but here, this reminds me a lot of when I was in a defense lawyer and you're doing death penalty work. Sometimes, when there's a true emergency, you do what you have to do. And so
Yeah.
they file in the Fifth Circuit and they file in the Supreme Court, and what happens?
Okay. So first, Judge Hendricks acts. So Judge Hendricks says, and everybody's waiting for him to say something. He says, I was working on this very diligently, and I was planning on ruling, and I'm understaffed because it's Easter Friday. I mean, he says that in the opinion more than once. And I have to also admit, the opinion is so poorly written that I was thinking this person's understaffed. This is not a well-drafted opinion.
But to be fair, this is a time crunch.
100%. So I was going to say, to be fair to him, it's a time crunch. I think under one count, the ACLU then acts within about an hour. So that's one. Two, also to be fair, he does make a legal argument that I think at a minimum is perfectly reasonable. Argument that might be wrong at the end of the day when under technicalities, but he says, now that you have taken this on appeal to the Fifth Circuit, you have divested me of jurisdiction. So he basically says, I can't do anything anymore because look what you just did. You took it away from me. So that's what he does. That is the holding of his opinion, and he's done. He's out. And now everybody's waiting. Will the Fifth Circuit act? Will the Supreme Court act? And two pieces that are interesting here are, oh, three pieces. Let me start with a bigger picture piece, which is what you said just a minute ago. And I think it's really important to underscore to people. That is, I do agree with you. I think that there is a race going on. And based on what the government ends up saying to Judge Boasberg, um, they are admitting what's being reported in the New York Times and ABC News, which is they are bringing people from across the country to imminently deport these individuals. And in fact, once again, in that particular hearing, it's the same lawyer, Ensign, and he says to Judge Boasberg that he can't even guarantee to Judge Boasberg that they won't leave on Saturday. So there is this.
Yeah. And so let me just ask you about that. To back up, we've talked about Judge Hendricks in
Yeah.
Texas. We've talked about the Fifth Circuit. We've talked about going to the Supreme Court. How does this then also end up in front of Judge Boasberg? And
Yeah.
if people remember, this case originated before Judge Boasberg, and there's still some things going on in front of Judge Boasberg. But the Supreme Court ultimately said, this case has to be brought where the people are,
Yes.
through what's called a habeas. And so, while there may be pieces that will be in front of Judge Boasberg, because that's where people are, or even if there are people now in El Salvador, they may be able to bring it before Judge Boasberg too, because they obviously are not in any U.S. district. But that's why you have cases in the Northern District of Texas. You have a case, as you said, in the Southern District of New York, because the Supreme Court had said, we believe in due process. We believe people have to have notice and an opportunity to be heard. But the vehicle you have to use is in the location where the people are.
Yes.
So how does this get before Judge Boasberg, which is yet another forum?
Yes. So, like those death penalty lawyers, they're trying everything. They try something that is a very reasonable shot, which is to go to Judge Boasberg on an emergency motion. In that, on April 16th, so a few days ago, they had submitted a new motion for a TRO, and the temporary restraining order was based on the idea that the Supreme Court has ruled that individuals who are going to be deported under the purported authority of the Alien Enemies Act require notice. And the ACLU's argument is a strong one, which is that constitutional right to notice is not about habeas. So that could be brought anywhere, because it's independent. And in fact, I think they could have made a better argument, honestly, in the hearing. At least I heard the second part of the hearing, and I didn't see any reporting on the first part, in which they could have said, Judge Boasberg, we could be bringing this case for people who are not even in confinement, just to give you a clear picture that this is not about habeas. Somebody who's just walking free right now, but the government has either determined or has a high risk of saying that they are a TDA member, and therefore would just put them into the Alien Enemies Act pipeline to deport them. And that each of these individuals require notice, and what they're asking for is 30-day notice, because it has become apparent through some of the other litigation in Southern District of Texas that the government is trying to argue that at best they only need to give people 24 hours notice. And so what the ACLU does very smartly on Friday is say, okay, we now want an emergency motion because we've just heard people being loaded onto the buses already. They're on the buses already, and they're about to be put on the planes. Judge Boasberg, you have jurisdiction on an independent constitutional right of notice, and that can be nationwide, in terms of if you issue a temporary restraining order. So it could clear all of this, because otherwise they're having to run to each of these districts and file habeas claims in the separate places that they're even aware that people are being deported. And Judge Boasberg essentially says two things. He says, and the first one is really quite remarkable. He says, and I'm going to quote, this is in the New York Times, they got the exact quote. On the question of the constitutionality of what the government's doing, he says, quote, I strongly doubt that the notice, particularly with a short time frame, complies with the Supreme Court instruction, where it doesn't give anything about the right to challenge or seek a hearing, end quote. So he's basically saying you're kind of right on the merits. And it's chilling because it's just so obvious. So he's willing to say that from the bench. And then he says, I don't have jurisdiction. And he says, I don't have jurisdiction because this is just too close to the line of what the court already told me I shouldn't hear. these kinds of cases, because we were talking about notice earlier when the Supreme Court said, no, you have to bring this in habeas. So I don't want to cross that line. I think he's probably also thinking in the back of his mind, this is going to the Supreme Court regardless, so they're going to have to decide. So why should I interfere? And then the second thing he basically says is, I've got to practice some form of abstention or comity. So it's not required. But look, isn't this case being heard in the Northern District of Texas? Judge Hendricks has it. Isn't it right now being heard being put before the Fifth Circuit? I don't want to take it away from them or interfere with them. The ACLU lawyer is also really smart and certainly saying, why don't you just rule that just stay, put it in a TRO right now that says this is a TRO until the Fifth Circuit rules. So you haven't interfered with them. And Judge Boasberg doesn't want to do it for the two reasons. And I think
And to
that's
be
also a reasonable
fair,
basis.
to be fair, I understand if you're the ACLU why you're doing what you're doing, but to be fair, he's really being asked to issue an order that the judge with, let's just say, primary jurisdiction had actually said no to.
Absolutely.
And so I'm not faulting the ACLU, but I can also really understand the bind that it put Judge Boasberg in to say, a judge has ruled on this and now you've appealed it, and that's really your avenue. I just want to talk for a moment, big picture, about Judge Boasberg saying that I really find it hard to see how you have complied with the Supreme Court's ruling. And I
Yeah.
want to make sure people understand the Supreme Court, when it, in many ways, affirmed Judge Boasberg by saying people are entitled to due process to challenge their removal under the Alien Enemies Act. You just have to do it in this vehicle called habeas. Said that people are entitled to notice and a meaningful opportunity to be heard. They're entitled to notice and a meaningful opportunity to be heard. So that's the Supreme Court ruling. There was no dissent from that decision. And that came up in connection with the two plane loads of people who had been removed without that notice and without that meaningful opportunity to be heard that we know of. There's just no suggestion that that was complied with. And so here, that is what Judge Boasberg's reacting to, saying, I don't see how what you are trying to do and race through in the Northern District of Texas complies with that. And I want to make sure people understand big picture what the government is doing here. These people are in detention. So there's no rush, right? There's nothing, they're not going to be able to hurt somebody in the populace. If they are subject to removal, there's nothing that prevents the government from giving notice, letting them speak to their counsel, letting them challenge the lawfulness of the Alien Enemies Act, which is a huge, substantial issue, whether the Alien Enemies Act even applies legally here. And then second, even if it does apply, the second issue is, does it apply to me? Am
Right.
I within that group? Am I, for instance, the mistake? I am not in TDA. I'm not in that gang. And so even if you win your legal argument, you lose your factual argument. There's no reason and no rush that should happen unless you really want to, A, deny people their opportunity to be heard, and B, not have the courts get involved. In other words, you want unilateral, unchallenged authority to do this. That would be the only reason I can think of to rush them out of the country, with, by the way, the result being that everyone knows that you're going to take the position once they're out of the country that they're now out of your control. And if you made any
Right.
mistakes, it's too bad. It's on you. And we know that from the Garcia case. So that's sort of, I just want to make sure people understand how sort of both, I think, lawless and callous that is. And this is something Judge Wilkinson the judge in the Fourth Circuit spoke to when he said, you are saying, government, that Mr. Garcia in a separate case is a bad person. And he says, perhaps and perhaps not. But if you are so confident that you are right, that's what you will do at a hearing, and you'll present the proof, and a court will decide that. And that essentially is what all of this is about, which is, shouldn't these people have an opportunity to say you are not acting within the law and factually you made a mistake? Which we know, by the way, happens because they've conceded that happened with Mr. Garcia. And so um, I think where we have now left this is that you have two district judges who are not granting a stay. You have an application in the Fifth Circuit for a stay, and you have the emergency application in the Supreme Court for a stay. So what happens in the Fifth Circuit and the Supreme Court? Who acts first, if we know?
Um, can I back up and just jump in with a couple other comments?
Yeah, sure, sure, sure.
Yeah. So, two comments are, one, just so folks understand who Judge Wilkinson is. He is a conservative jurist and a stalwart of conservative jurisprudence. A Reagan appointee. He's been on the bench for a while, in the sense that he also has an enormous following among conservative lawyers. And in 2003, he in fact penned the opinion in Humvee v. Rumsfeld, in which he upheld the ability of the US government and the President of the United States, acting with commander-in-chief authority, to indefinitely detain a US citizen who was captured in Afghanistan without a hearing. That's who we're talking about. And he is saying, we're about to go off the cliff. And he cannot believe that the Trump administration is even appealing the Abrego-Garcia order by the district judge. That's just one piece. And then a second piece that's also just, I think, really helpful for people to understand what situation we're in as a country right now. The Wall Street Journal in the last 24 hours issued an editorial board piece, the title of which is Judge Wilkinson's Sage Advice on Abrego Garcia. And he basically says the exact same thing as, is Abrego Garcia a bad actor? Is he a potential MS-13 member? Perhaps, perhaps not. It doesn't matter. They say, quote, the White House wants this to be a fight over immigration policy, and it claims Mr. Abrego Garcia is an MS-13 gang member. But this is beside the legal point. No one denies that Mr. Trump has the power to deport an illegal migrant, especially a gang member, but they get, and end quote, and then they go back to Wilkinson saying, you get due process. And if we don't give due process to the people that we think are guilty, then everybody's at risk.
Yes. And by the way, I have made this point, and you know who should know that more than anyone? Somebody who has been a criminal defendant in 4 criminal cases, 2 federal and 2 state. That would be our current president of the United States. He enjoyed due process. He enjoyed all of the rights that he is now denying in opposition to the courts, these people, things that he enjoyed. He should be the first person to say, you know what, prosecutors, courts can get things wrong, and people are entitled to due process. It doesn't work where it's, you know, off with your head, trial to follow. You know, as Judge Beryl Howell said, that might be amusing in Alice in Wonderland, but that's not how it works in the American system of justice. So, okay, Fifth Circuit and Supreme Court.
I'm going to say one more thing, then I'll do Fifth Circuit, Supreme Court. Tom Jocelyn and I just wrote a piece at Just Security, published it Saturday morning, in which we try to articulate, here are all the 3 instances in which Mr. Abrego Garcia's due process rights have been violated, and 2 of which the government has already admitted that they were not in compliance with the law.
Okay.
That's what it should be about.
Moving along.
So the Supreme Court rules, as you said at the beginning, right around 1 a.m. When they rule, the ruling, you can see by the way it's written, they don't realize that the Fifth Circuit has actually ruled by then. They are, in fact, ruling on the assumption the Fifth Circuit has not yet decided the issue, which is also astonishingly remarkable. And they're saying, here's our order, which is to freeze everything in place. Nobody shall be deported out of the Northern District of Texas under the Alien Enemies Act. And when the Fifth Circuit rules, then you, Solicitor General, we invite you to, you know, bring your petition as soon as you like. What was actually happening is right before midnight, based on the docket, the Fifth Circuit actually did rule. And the Fifth Circuit rules to deny the emergency motion And the denial is on this kind of more of a technical ground, which is the idea that it was, in a certain sense, premature to try to bring the case before the Fifth Circuit before Judge Hendricks had an opportunity to decide. So there's some realm of legality, reasonableness in that, except I just want to point out one thing about that Fifth Circuit order, which is either it's at a minimum badly mistaken or worse, disingenuous. So I don't know. So going back to the early part of our conversation, reminding folks what's happened in the Northern District of Texas is that Judge Hendricks has said, I don't need to issue a TRO for the two named plaintiffs because the government has agreed that the government will not deport those two individuals. And the ACLU is saying, okay, we accept that, but it's the entire class. It's the plane loads of people that right now are not being certified as a class. We want you to protect them. And lo and behold, here's what the Fifth Circuit says to the reader who would not know that background. They say, quote, just yesterday, the district court entered an order indicating that the government states that authorities will not remove the petitioners during this litigation, and it will alert the court if that changes. If petitioners are concerned that respondents' position has changed, they should have litigated these concerns before the district court. To which the answer is, yeah, the petitioners are just the two people.
Right.
It's like they've only promised for the two people. And the first footnote in the appeals to the Fifth Circuit and the entire appeal to the Fifth Circuit on an emergency motion is all about the class. It's about all the other people, the plane loads. So I just thought, just an astonishingly badly reasoned basis to reject them.
So I wanted to talk for a moment just about just how the timing of this, shortly before 1 a.m. Supreme Court
Yes.
decision, because in the case before Judge Boasberg, where he is asking lots of questions of the government lawyer, of whom it's the same lawyer he has been dealing with and dealt with in the whole issue of like, are planes taking off and where are they, et cetera.
Yes.
So he has lots of reason to be skeptical and concerned about the representations. The lawyer says there will be no planes taking off. There'll be no removals from Texas today, meaning Friday. However, Judge, I'm required to tell you that we reserve the right to resume flights on Saturday. To be clear, that means 12:01. Right? Saturday, I mean, so what is being told to Judge Boasberg is Friday, don't worry about Friday, but this is now, hours away. And so for the Supreme Court, there is this gap in time where you can just imagine what needs to be happening where remember you have 9 justices, they have this application, and the reason you have this thing happening at just before 1 a.m. is could imagine being a fly in the wall where they know, one, they previously ruled that due process requires a notice and a meaningful opportunity to be heard, and that doesn't seem to be happening. 2, in the Garcia case, they said that the government has to facilitate his release, and that doesn't seem to be happening. And now the only assurance that they have is this assurance that nothing will happen on Friday, but as of the stroke of midnight, planes could be taking off. And so one of the unusual things here is that the Supreme Court is jumping over the Fifth Circuit because they believe the Fifth Circuit hasn't ruled, because it says the matter is currently pending before the Fifth Circuit. So that's the indication that they don't know that that's actually moot at this point, which I'm not faulting them. This is all happening very, very quickly. And second, they don't wait for their 2 dissents. And it notes that Justice Thomas and Justice Alito dissent from the court's order, statement from Justice Alito to follow. And that's something they obviously can't wait and don't want to wait for that. And they aren't waiting for that precisely because that amount of time is all time that there is no TRO in place with respect to Texas. And so they even now they've given like almost an hour, but you can imagine that internal discussion of we have to get this out the door. And then, unlike the Garcia language, which is you need to facilitate his release, I just want to read for people, sort of to go
Mm.
back to where we started, the language from this 7-2 decision. The government is directed not to remove any member of the putative class of detainees from the United States until further order of this court. Directed not to remove. This is not, we would like you to, this is not facilitate that, or we request. This is a direction from the highest court in the land. And, this falls into what a friend of mine calls fool me once, shame on you. Fool me twice, shame on me. And I think that is one of the reasons you see this. Um, Final thing, maybe to talk about, is we are seeing a little bit of, from the discussion we're having, that this is a bit of a whack-a-mole
Yeah.
because the court has said that habeas petitions need to be brought where people are. You now are seeing this proliferation of cases. So you have Colorado, Texas, New York, DC, and various judges ruling with respect to the people in their jurisdiction. Even the putative class is about the people in their jurisdiction, as opposed to sort of this nationwide issue, which just makes the burden on groups like the ACLU and ultimately the detainees that much harder. But be that as it may, I do think this is a good news story. This is the Supreme Court standing up. Just last night, I was having a discussion about the Supreme Court, and with there's the I was sort of on the more optimistic side, not crazy optimistic, but I mean on the seeing good signs, and people were like, no, you're being too, glass half full, glass half empty. And I do think here that you do have the courts at the not just the district court level, as we noted, Judge Wilkinson at the Court of Appeals level, and then ultimately the Supreme Court doing what I think they have to do and need to do. And I have still been of the belief, and I'd be interested in your view, that we will not see a direct violation of a Supreme Court order. I can see that we will have arguments and that we may not think are the greatest and may get very close to not good
Mm.
faith, but I still think, and it may be just because I worked in government I'm a lawyer. I worked in government for over 20 years. I've been a defense lawyer for 10 years. I think I'm an institutionalist, so I may be too beholden to the idea that institutions hold. But I think there are many people in the government who are going to be very, very disrespectful, but I'm not sure we're going to see the White House go that far. What do you think?
So I I think they crossed the line in Abrego Garcia. So I think they knowingly crossed the line in Abrego Garcia. I've thought the same thing, that to me, the one big question is, will the government ever say, basically like in a court or to the courts, what some people like Stephen Miller, et cetera, are willing to say in Fox News, like, we do not need to heed your command. This is Article 2 power. But the other one is, do they also make farcical arguments that just are obviously
Yeah.
bogus? And
Well, that
so,
I think that may
yeah,
happen.
because I just think that the Supreme Court did say that Judge Sinis's order in Abrego Garcia was proper, that she could require the administration to take steps to facilitate his release from El Salvador, and for them to turn around as the administration and the DOJ and in her courtroom say, oh, all we need to do is change domestic opportunities for him to come back if he were to show up at the border, but to do nothing vis-a-vis El Salvador. Unfortunately, I think they're actually operating in direct defiance of the Supreme Court, and they know it. Is my best
Look,
speculation.
that's a reasonable argument. Judge Wilkinson agrees with you.
Yeah,
That he didn't phrase it as a defiance of the Supreme Court, but he made the exact point that you are making, that that was a that interpretation of facilitate could not be what the Supreme Court meant, and doesn't even comport with the English language. I think his
yeah.
line was facilitate is an active verb. So, that was something that as a nerd grammarian, I
Yeah,
appreciated,
yeah,
because he's like sitting back and waiting for him to show up is not facilitating. In fact, you're facilitating his detention. You're not facilitating his release.
completely. Yeah.
And again, that's Judge Wilkinson. So, Ryan, this is a continuing story. I hope we get to do this again. Let me just remind people that Just Security is now available to you in like a million different ways. The old-fashioned way of going online and reading it. But there are many other ways, including this Substack. And Ryan, you're doing sort of periodic Substacks during the week, so that you can get information that way. This is obviously a continuing story. Hopefully, this people get a lot more information from this and will understand as this progresses, because we're going to see much more litigation, including in the Supreme Court on this issue, and there are various contempt proceedings that are in various stages in Maryland and in DC that all relate to this issue. And Ryan, to your excellent point, that they may in fact already be in contempt of the Supreme Court decision in the Garcia case. So thanks so much. Enjoy the rest of your Saturday afternoon.
Thanks. Great to be with you.